Thank you, Mr. Chairman. Thanks to our witnesses participating with us today. Judge Starr, I'd like to start with you, if that's okay. Would you agree that removing Special Counsel Durham for anything other than cause would flatly and inexcusably contradict the administration's claims that the Biden Justice Department will be free from political pressure?
Yes, it would take the form, as it were, of a Saturday night massacre. We all recall that or know it from history. I recall it ever so vividly, as most members will, which is the President of the United States acting imprudently and resulting in an act of conscience by the then Attorney General of the United States, Elliot Richardson, who said, "I cannot, in conscience, fire the special prosecutor," as Archibald Cox was known. It would, in fact, create a firestorm absent the most compelling circumstances. And I have great confidence in Judge Garland, given his record of integrity and his independence of judgment, that were there to come such a suggestion from anyone, I'm not suggesting that the President of the United States would do this, but anyone as a senior leader in the administration suggesting this kind of action without, again, the most compelling circumstances would be a grievous mistake.
Yeah, thank you, Judge Starr. Professor Blackman, let's go to you for a second. Is there a point at which what's known as prosecutorial discretion simply becomes executive fiat? And if so, at what point does that run afoul of the Constitution?
Absolutely. The president has a duty to take care that the laws are faithfully executed. And that means something. Congress gives the executive some latitude, some discretion, but the president can't simply decline to enforce the law he dislikes. And I think we've seen this pattern all too often. I think some of the executive actions in immigration have amounted to an abdication of the law. I think even in the first 100 days, the Biden administration tried to say no more deportations for 100 days. I don't think he has that much discretion. We've seen perhaps a complete moratorium on the death penalty. That can go beyond the bounds of discretion. I think Congress should perhaps do more to legislate to make clear what those rules are. But I'm troubled by the failure to faithfully execute the law. It's something that I think we're seeing increasingly.
So you mentioned prosecutorial discretion being invoked as a doctrine in the context of immigration. I assume you may be referring there, among other things, to DACA. It reminds me of a piece that you wrote with my friend Ilya Shapiro about 1.5 years ago, in which you said that if federal law, in fact, supported DACA, then certain key important provisions of the INA would themselves run afoul of the non-delegation doctrine. Can you explain what you mean there?
Of course, and I'm thankful my colleague at Cato, Ilya Shapiro, gets a shout out. Congress has created a very elaborate scheme of granting discretion to the Department of Homeland Security. For example, you can let the secretary set priorities. That's a fairly nebulous provision. You can set priorities. The Obama administration, and perhaps now the Biden administration, has said these nebulous provisions about granting discretion to set priorities let them basically create this elaborate program by granting lawful presence to over 1 million people and grant them work authorization. If you can read the INA that broadly, then the entire INA is perhaps unconstitutional, right? You should not be able to read it. The Supreme Court punted on this issue. Chief Justice Roberts does what he often does and declines to decide important questions. And they just didn't decide it. But eventually the courts will have to decide the DACA litigation. And this is something that Attorney General Garland will be litigating now, defending the policy for the new administration.
So in other words, you've got concerns with the notion that the President of the United States could just tell the Department of Justice in advance to not comply with this specific provision of the INA. That would concern you.
Oh, very much so, yes.
Section 241 of the INA, of course, provides that, quote, when an alien is ordered removed, the Attorney General shall remove the alien from the United States within a period of 90 days, close quote. On what planet, in what universe would it then be appropriate to convert the word shall into may not? or may decide not to?
That's exactly right, Senator. Generally, the word shall means must. That's how we read the word shall in the law. And Congress has created a very elaborate scheme by which the Attorney General can cancel removal. There are very specific rules. But the moratorium enacted on day number 1 was across the board. It's every deportation shall stop. A federal judge down in Texas, in Corpus Christi, declared that policy unlawful. As far as I'm aware, that's not been appealed up. That's still in the district court. I think we'll see more of these sorts of efforts to try to just not enforce parts of the law that are unpopular. Yesterday, Senator Sass made a point that over time, Article 2, the executive has grown. Well, Article 1, the Congress has sort of shrunk. I would hope it reverses and Congress asserts itself more over immigration and puts some teeth into the limits on the president's powers.
Thank you, Mr. Chairman. I see my time's expired, and I'd note here that this is a part of a consistent pattern that's been under the leadership of Republican and Democratic Congresses and White Houses combined over the last 80 years, in which we've taken power away from the American people in 2 steps. First, we've taken non-federal power and brought it to Washington. Within Washington, we've taken that power, or any power that we might have previously had, and handed it over to the executive branch. We can't do this anymore. We've got to reclaim our role under Article 1 as the lawmaking branch. Thank you.